subsection of the rules that we're going to take up is the safekeeping of funds and other property. So the safekeeping of funds and other property, this subsection by itself makes up 2 to 8% of your total MPRE examination. The first rule that I would like to cover here is all about the safekeeping of funds and other property that might belong to your clients. The first part of this rule says that when a client prepays a lawyer for the lawyer's services or otherwise gives the lawyer property, the lawyer is supposed to keep it separate from their own, and they must not steal it, borrow it, or use it for their own personal advantage. So that is the big rule. I just want to stop there. You're not supposed to take that property, it's usually money, and use it for your own purposes. It's supposed to be kept separate from your own. When a client gives you a large amount of money, the lawyer should put the funds into a separate account so that this client can keep all of the interest in which this large amount of money earns. If a client gives a lawyer a small amount of funds, the lawyer should put this money in a pooled client trust account. All states have interest on lawyers' trust accounts, or IOLTAs is what they're usually referred to, whereby the interest earned on these pooled client monies goes to the state bar or legal foundation, and it is used for public use. This has been taken up by the Supreme Court of the United States, where it was alleged that this taking of clients' interest on their pooled monies was considered a taking, and the people who made this type of claim lost. The Supreme Court has specifically held that this is not a taking and that this is permissible. So just to stop there and recap, if your client gives you a large amount of money, keep it separate in an interest-bearing account so that they can keep the interest. If your client gives you a small sum of money, put it in your IOLTA account where you put all of the other small sums of money from different clients, and that interest goes to the State Bar Association or Foundation for public use. The rule also states that your client trust accounts must be held in the state where the lawyer practices, or if they're going to be held elsewhere, they should be done so with that person's consent. When it comes to the holding or the keeping of other types of property, meaning not money for your clients, the rule states that other property shall be identified as such and appropriately safeguarded. Complete records of such account funds and other property shall be kept by lawyers and preserved for a period of 5 years after the termination of representation. And the rule specifically states that securities should be kept in a safety deposit box, except when some other form of safekeeping is warranted by special circumstances. So again, just to stop there, if you are in the business or you find yourself in the circumstances of holding on to your client's property that is not money, you should follow the general rule where you keep it separate and you safeguard it and it is clearly labeled as your client's. So for instance, if your client gives you a diamond ring to hold on to, that should not be in your own personal jewelry box. That should again say be in a safety deposit box where it's clearly labeled and being safeguarded as your client's. So turning back to these client trust fund accounts, the rules state that any money that a lawyer receives but has not yet earned, so let's say your client gives you some sort of upfront deposit for your services, the lawyer must immediately put this money in the client trust fund account that is again separate from the lawyer's own account and separate from the law firm's operating business account. Lawyers and law firms are not allowed to put any money in these client accounts or in these IOLTA accounts unless it's for the sole purpose of paying bank charges. But even then, the lawyer and or the law firm is only ever supposed to put in as much money to cover those bank charges that are being assessed by that lending institution. So again, we want to make sure that there is no commingling of the lawyer or law firm's funds with the clients. Lawyers may withdraw funds only as the fees are earned or expenses are incurred. Otherwise, if fees are not earned or expenses are not incurred, the money is still the client's and therefore should be kept in the client trust fund account. And when it comes to disputed claims, if there is some sort of dispute, the lawyer must keep the disputed portion in the client trust fund account until the dispute is resolved. The lawyer shall promptly distribute all portions of the property to the interests that are not in dispute. So let's say, for instance, your client gave you the upfront deposit for your services in the amount of $10,000. Let's say that you handled the client matters successfully and you billed your client $8,000 for your services. However, your client believes that your services should not be $8,000, but instead should only be $7,000. What do you do? Well, following the rules here, the rules make it pretty clear that you should distribute the funds that are not in dispute. So, if you and your client both agree that at a minimum you're owed $7,000, you should make sure that you pay yourself that $7,000. Based on my basic facts here, I said you as the lawyer are claiming that you're owed $8,000, meaning at a minimum you and your client agree that $2,000 belongs to your client. Because remember, the client paid you $10,000 up front. Lastly, you hold the amount of money in dispute, that $1,000, in trust until the dispute is resolved. So the way that I handle these problems is first things first, pay yourself, the lawyer, what's not in dispute. Secondly, give back to your client what everyone agrees is the client's. And lastly, whatever amount of money is in dispute, you hold it in trust until the dispute is resolved. So that wraps up that subsection of the rules.